When you receive a summons from a Polish civil court to testify at a hearing, the summons will identify the parties to the dispute, what is at stake in the dispute, and the court before which the case is pending. At the end of the summons, you will find a notice on the penalties you face for failing to comply with the summons.
Now you're probably wondering, do you definitely have to participate in the hearing? What rights do you have as a witness? What are the witness's obligations? How will the testimony be taken?
My name is KONRAD GROTOWSKI and this is News from Poland Business and Law, a program prepared by lawyers from Wardyński Partners for foreigners acting as board members in Polish companies, foreign investors in Poland and their foreign advisors. My guest today is STANISław DROZD, attorney, solicitor-advocate of England and Wales, not practicing, and a partner at Wardyński Partners. Together we will answer above questions. Let's first explain who a witness is.
A witness is a person unrelated to the parties. The dispute does not concern the witness's rights or obligations. In this respect, if a company is a party to a dispute and the court hears the testimony of the company's management board members, they will testify not as witnesses, but as a party, as the board members in some sense embody the company.
Who indicates to the court who should be called as a witness in the trial? Witnesses are identified by the parties, by the claimant in the statement of claim and by the defendant in the statement of defense. Is it possible to refuse to testify? As a rule, no. A person called as a witness in a case between two companies, the most common situation in commercial disputes, has no right to refuse to testify. A witness, unlike a party, has an obligation to testify.
There is an exception when one of the parties is an individual and the person called to testify as a witness is the spouse, parent or child of the party. Such a person has a right to refuse to testify, and before the hearing the court must instruct the witness of this right. In addition, during the course of the hearing, any witness, even one unrelated to either of the parties, can refuse to answer specific questions if the answer could expose the witness to criminal liability or a serious and immediate financial loss, or if the testimony would violate professional confidentiality.
What can you do if you cannot appear at the time stated by the court?
An anticipated failure to appear, for example due to illness or a previously planned foreign holiday, should be justified. However, a failure to appear due to illness must be justified by presenting a doctor's certificate, and not just any doctor. The certificate must be issued by a special court-appointed doctor. This is intended to protect the judicial system against the abuse of certificates issued by friendly doctors, which used to be a common problem in Polish court hearings.
What happens if a witness fails to appear with no justification? The court can first impose a fine on the witness. The current amount is 3,000 Polish zlotys, about 650 euro. Then the court will once again summon the witness to appear. If the witness again fails to appear, the court can again impose a fine on the witness. But it can also order the police to bring in the witness by force from their home or workplace. What form does the testimony take? The rule is that the witness testifies orally.
But the court may order the witness to testify in writing. In that case, the court will issue a written summons to the witness, specifying the factual issues on which the witness will testify, presenting the questions to be answered by the witness, these are formulated by the lawyers for the parties, and setting the deadline by which the witness must send answer to the court by post. The court will also instruct the witness of the penalty for perjury.
Where is the oral testimony taken? Before the COVID-19 pandemic, the rule was that witnesses testified orally during a hearing in the courtroom. But at the start of the pandemic, testifying during remote hearings became the rule.
The court can decide to hold a hearing in person rather than remotely when conducting such a hearing is necessary for the case, and conducting the hearing in the courthouse will not pose an excessive risk to the health of the participants.
Currently, a party calling a witness provides the witness's mobile phone number and email address to the court. The witness receives an email from the court with a link to the online connection. On the day of the hearing, at the request of the court made by telephone, the connection is switched on or off via internet.
After arriving at the courthouse, you will first pass through security, much as when entering the departure gate at the airport. Then find the room indicated in the summons. There you can check the docket. This is an electronic or paper list posted next to the entrance to the courtroom. It includes the names of the witnesses and interpreters along the time for which they were summoned. If for some reason the hearing has been moved to a different courtroom, this will be noted on the docket.
The courtroom is always arranged as follows. The judge sits at a bench under the Polish state emblem. Immediately in front of the judge's bench is the lectern, at which witnesses or parties testify standing. The claimant and the claimant's lawyers sit to the judge's right, i.e. to the left from the perspective of the witness who testifies standing in front of the judge. The defendant and the defendant's lawyers sit to the judge's left. A witness who is present to testify but is not testifying at the moment should sit in the seats for the public, usually found at the back of the room directly facing the judge's bench.
When the hearing is held in the courthouse, not remotely, members of the public may be present. This might include, for example, journalists or former employees of a corporate party.
In the case of remote hearings, in practice, the public have no access to the hearing, because typically the link to the remote session is received from the court only by the participants in the particular session, i.e. the parties, counsels, witnesses, and court-appointed experts.
The order in which witnesses testify is based on the hearing plan agreed by the judge and the parties. If there is no plan, the order is determined by the judge. Witnesses who have not yet testified cannot be present when other witnesses are testifying. Instead, they have to wait their turn in the corridor outside the courtroom. The clerk will invite them into the courtroom at the appropriate time.
How is the hearing conducted? If you are a foreigner, you probably don't speak Polish fluently. Thus, the court should take your testimony with the assistance of a sworn interpreter. The party calling the witness should notify the court of this in advance, because the court will arrange for the attendance of the sworn interpreter. You do not have to appear at the hearing with your own interpreter.
The court will start the interrogation by asking the witness questions about himself and his relation to the parties. The court will ask the witness for his age, profession and education, and whether he is affiliated with either of the parties to the dispute. In responding to the judge's questions, the witness should address the court as Your Honor, as an institution, never as a Sir or Madam. The witness must present the court with his or her passport or Polish identity card.
The judge will warn the witness of the criminal liability for perjury and ask the parties whether to take an oath from the witness that they will testify truthfully. With the parties' consent, the court will not require the witness to swear an oath. But if one or more of the parties suspect that the witness may intentionally stray from the truth when testifying, or in colloquial terms, lie, they will ask the judge to have the witness swear an oath to tell the truth. Then everyone, except the judge, will rise, and the witness will swear that he or she will tell the honest truth, concealing nothing known to them. If the witness testifies in writing, he or she will make an oath by signing the words of the oath.
Here we should explain the issue of criminal liability for perjury. Under the Polish Criminal Code, anyone providing testimony as evidence in a judicial proceeding who testifies falsely or conceals the truth is subject to a penalty of imprisonment of 6 months to 8 years. However, a condition for liability is that the authority admitting the testimony, here the judge during the hearing, warned the witness of criminal liability for perjury or took an oath from the witness.
Now let's return to taking testimony. At the start of the testimony, the judge will ask the witness what he or she knows about the case and from what source. Then the judge will ask more detailed questions. When the judge has finished, the parties will have an opportunity to ask questions, typically through their lawyers. First, the witness will answer questions from the party that called the witness. Then, the lawyers from the other side will ask questions. When testifying in the courtroom or remotely online, the witness should answer off the top of his head, i.e., they cannot consult documents or notes.
During the hearing, the image and sound are recorded. The camera is located above the judge's heads. In addition, when the witness testifies, the judge will usually provide a running dictation to the court clerk of what the clerk should enter in the record documenting the witness's testimony. A witness who is fluent in Polish will hear what the judge dictates and correct the dictation on the spot if they notice errors. A foreigner who is not fluent in Polish will not be in a position to do this. But at the end of the testimony, the witness can ask the court to have the sworn interpreter read back the witness's testimony, and if the witness notices errors, he may request that the court supplement or correct the record. Witnesses do not have access to the case file, thus they do not have a chance to review the record of the testimony and will not be furnished with a copy of the transcript.
Witnesses whose testimony is mutually irreconcilable can be confronted with each other, but this happens very rarely.
The witness cannot leave the court until allowed to do so by the judge.
Reimbursement of expenses. If the hearing is held at the courthouse, i.e. not remotely, not online, and the witness must travel to the hearing from another city, the witness will have to pay for round-trip travel by train, air, or their own vehicle. And if the testimony is to be taken in the early morning, they will also have to pay for lodging.
The witness has a right to request the court for reimbursement of such expenses if they are reasonable. The judge may even award the witness an advance against costs of travel and lodging. The witness is also entitled to reimbursement of his or her daily earnings or income lost as a result of appearing in answer to the court's summons. These amounts cannot exceed a certain maximum established by law.
To obtain a refund of travel costs, expenses and lost earnings or income, the witness must make an application to the court. The application can be made orally for inclusion in the record of the hearing, i.e. immediately after the witness testifies, or in writing within 3 days after testifying. The refund is made by bank transfer to the witness's account.
And that's all we have on this topic. We hope this video has been helpful.
See you soon!